Are housing societies turning into Khap panchayats? A lot has been said about the fault line of builders. What about the faults of the elected members of Apartment Owner Association or RWAs? Is there any fundamental right of bachelor tenants in a housing society? What is the legal opinion when privacy and fundamental rights of bachelor tenants are violated? We will continue to raise questions. It doesn't matter whether the fault lies with the residents of the housing society or the builder. Builders harassing home buyers is a harsh reality of India. More often than not, builders play around the legalities and don't easily hand over the apartment maintenance to the buyers for long. Maintenance fee, as arbitrary as it could be, is the easy money for the builders. But what about the conduct of the apartment owners when they form their own RWA, Resident Welfare Association, or AOA in some parts, Apartment Owner Association, and they take over the apartment maintenance? Some harsh realities of housing societies and arbitrary rules of RWAs indicate apartments are not safe places if you are single or having an independent life and lifestyle than the majority of the home buyers. Some of the residents grouping together can easily turn the housing society into urban Khaps for those who don't fall in line, especially the bachelor tenants. Some case studies or some complaints that we have received. In Gurgaon, the RWAs issued diktats to the single tenants against guests of opposite sex. When objected by others, they leveled them to the extent of defamation for supporting prostitution. In a housing society in Noida, a female tenant was asked bizarre personal questions about her male friend by the security guards. On complaining to the facility management office said they can't allow male friends to the apartment of female tenants without verification. It has been noted that RWAs start issuing moral, ethical, and social diktats to the residents. The question is whether they do have any legal standing to do so. More importantly, what are the immediate options left for home buyers or tenants if the RWAs restrict their privacy, guests, and lifestyle choices? Can a bylaw framed by housing society be in contravention with the law of the land? Well, the legal stand is pretty clear on the subject that any bylaw cannot ever be in contravention to the law of the land. It shall be always in sync with the spirit of life, right to life, guaranteed under Article 21 of the Constitution. Any resident member who is aggrieved by the arbitrary and unreasonable actions of a RWA can file a suit under Section 6 of the Societies Registration Act 1960. The RWA can be sued in the local civil court also in the name of the president or secretary. For example, such law is substantively ultra vires as per Section 14 of UP Apartment Ownership Act 2010. In Mumbai, the Bombay High Court in the case of a cooperative society has held that the bylaws of a society cannot violate the provisions of the Maharashtra Cooperative Societies Act 1960. If they do so, they will be declared ultra vires and struck down. But for the bachelor tenants, as long as one is paying the rent, No RWA or landlord can define who should be their guest, what they should bear, at what time they should come and leave the society, and what kind of food habits one can have. However, in practice, the RWAs often transgress their voluntary jurisdiction of maintaining the society and start defining the rules. If one fails to comply with, they have all the arm twisting tactics in the book. RWAs have no legal sanctity to issue moral, ethical, and social diktats to society members. No apartment owner can be stopped from renting out apartment to bachelors. No bachelor resident can be stopped from entertaining guests, including the one from opposite sex. If a bachelor tenant is harassed by the RWA, one has the legal right to sue the RWA and ask for compensation. RWAs have absolutely no right to come with their dictatorial diktats. However, for a resident to continue residing in the society, there may be certain compromise done or enter into a negotiation for the overall welfare of the society. But in no way the RWA can violate individual rights of its residents. Residents can approach civil court with appropriate jurisdiction for compensatory relief against the RWA if their rights are violated. That will be in a way amounting to fighting with your own people, and hence most of the people don't do that. RWA often transgress their legal authority to issue moral, ethical, and societal diktats to the residents. But in any such measure is in direct violation of the fundamental rights prescribed in the Constitution of India. The RWA starts framing unreasonable conditions which restrict the sale or renting of flats. It will directly violate an apartment owner's right to property under Article 300A of the Constitution of India. The RWA's bylaws and resolutions must be limited to the mandate of governing the society affairs and nothing more. An RWA cannot transgress its statutory mandate under the Apartment Ownership Act of respective states. It has to act within its jurisdiction and cannot abuse its power to the detriment of residents or others. RWAs are typically registered under the Societies Registration Act of 1960. The Apartment Ownership Act of various states also clearly define that RWA has to handle everyday affairs like maintenance, facility, and general administration of the project premises. It cannot interfere with a resident's right to use his flat. The RWA has to operate within the borders prescribed by the Act. For example, the Uttar Pradesh Apartment Promotion of Construction, Ownership and Maintenance Act 2010, Section 14 states that the responsibility of a RWA is to look after the affairs in relation to the apartment's common areas and facilities. Further, Section 5/1 of the UP Apartments Ownership Act 2010 states that an apartment owner shall have exclusive ownership and possession of his apartment. Therefore, the RWA cannot stop him from renting or selling his flat to any person irrespective of religion, caste or race. Hi. Thank you all for subscribing our channel and posting your comments. I appreciate. Trust me, I take time to read all the comments and I take your comments, feedback and queries with due professional seriousness. I would continue to make video on the topics and questions raised in the comments section as I aspire to make this platform dialogue driven. May I request you all to subscribe this channel and keep posting your comments. Our mail ID is given in the description and you are also free to ask questions through your short and crisp video. I will try my best to take your video queries and reply it in the subsequent video. Let's make this channel unique and dialogue driven. But we all have seen what had happened during COVID. It was the worst case study of humanity when the global pandemic was supposed to evoke the humanity side of the Indians. But it seems the COVID only added to the toxic behavior of the housing societies, where the dictats had gone beyond the social and moral policing. In a supposedly matured society like Mumbai, one housing society even imposed curbs during the peak cycle of COVID that the residents cannot invite their relatives, including the aged parents, to stay with them. In the Noida market, certain housing societies stopped the shifting in of the new apartment buyers, even though the area did not fall under the contaminated designated red zone. Across the country, there were reports of ill treatment meted out to the domestic help and other support staffs like drivers and cleaners. The question is, how many residents can afford to go against the housing society RWAs or the builder maintaining the society? Situation is even worse for the tenants who don't have a voice and could be thrown out of the apartment, citing any flimsy reasons. The bizarre incidents clearly suggest that the Indian home buyers need to evolve with their thought process. These are the reasons why the home buyers fail to unite against the builder. More often than not, the builders in this part of the world are smart enough to play one set of residents and one set of mindsets with the other one. Needless to add, the petty fights of the home buyers over these petty issues help the builder to retain the maintenance with him and continue to charge exorbitant amount month after month without any accountability. The builder also has moral high ground over lack of accountability, as he would claim that there is infighting among the apartment owners, and on his part he will hand over the apartment maintenance when asked to. When maintaining the apartment complex, the RWAs often get away with their bizarre behavior against the single tenants, as they claim before the court whenever a tenant challenges it. They claim before the court that they had only objected to hostelization of the apartment, and turning a residential apartment into a hostel falls under commercial activity, which can be disallowed in a housing society. The legal options and help might be in favor of the one who has suffered the dictatorial high-handedness of the RWA, but it is often not that easy to challenge them in the court of law. The onus of proving the illegal diktat is on the victim. The burden of proof lies with the victim. The neighbors might sympathize with the victim, but no one normally comes forward to testify before the court of law and face the wrath of organized coterie of RWA members. Housing societies are supposed to be very civilized place to live. But many case studies have come to us, many complaints have come to us, which clearly shows that there is a bias towards single tenants. There is a bias towards apartment owners who are single, who have a different lifestyle than the majority of the other neighbors, and they are harassed. Normally, such complaints don't reach to the courts, even though the law is in favor of the one who has suffered. But in practice, most of such urban Khap behavior goes unreported. Is this fair? I leave it to you. Thanks for watching.